Welcome to EUPrivacyForAll Session36 on GDPR, Article 40, Codes of Conduct. Article 38 on Codes of Conduct was finally renumbered Article 40. It stresses that Member States, the supervisory authorities, the European Data Protection Board, and the Commission shall encourage the drawing up of Codes of Conduct intended to contribute to the proper application of the GDPR, taking account of the specific features of the various processing sectors and the specific needs of micro, small, and medium-sized enterprises. Associations and other bodies representing categories of controllers and processors will be the one to prepare codes of conduct, or amend or extend such codes, for the purpose of specifying how to implement the GDPR with regard to fair and transparent processing, the legitimate interests pursued by controllers, the collection of personal data, the pseudonymization of personal data, the information provided to the public and the data subjects, the exercise of the rights of data subject, the information provided to and protection of children, and the manner in which the consent of the holders of parental responsibility over children is to be obtained, the measures and procedures regarding responsibility of the controller and privacy by default and by design, and regarding security, the notification of personal data breaches to supervisory authorities and the communication of such breaches to data subjects, the transfer of personal data to third countries or international organizations, or out-of-court proceedings. Controllers and processors that are not to comply with the GDPR and are not binded by it are free to adhere to codes of conduct that are subject to the regulation. The Code of Conduct shall contain mechanisms which enable the body referred to in Article 41 to carry out the mandatory monitoring of compliance. Associations and other bodies which intend to prepare a code of conduct, an amendment or an extension regarding an existing code shall submit such code, amendment or extension to the supervisory authority which is competent. The latter should provide an opinion regarding the compliance of such code, amendment or extension with the GDPR. Where the draft code, amendment or extension is approved, and where the Code of Conduct concerned does not relate to processing activities in several member states, the supervisory authority shall register and also publish the code. Where a draft code relates to processing activities in several member states, the supervisory authority has the obligation, before approving the draft code, amendment or extension, to submit it to the board, the European Data Protection Board, shall give an opinion on the code, amendment or extension regarding the regulation, but also regarding appropriate safeguards guaranteed by the code. Where the opinion referred to in paragraph 7 confirms compliance or appropriate safeguards, the European Data Protection Board shall submit its opinion to the Commission. The Commission may, by way of implementing acts, decide that the approved codes of conduct, amendments or extensions submitted to it have general validity within the Union. The Commission shall ensure appropriate publicity for the approved codes, and the Board shall collect all approved codes of conduct, amendments and extensions in a register and shall make them publicly available by way of appropriate means. Let's now focus on Recital 98 and its specific input. Associations and other bodies representing categories of controllers or processors are to be encouraged to draw up codes of conduct in order to facilitate the effective application of the GDPR. It might be sector-based and carry some specific provisions regarding micro, small and medium enterprises. In particular, and this is a key input, such codes of conduct could calibrate the obligations of controllers and processors, taking specifically into account the risk likely to result from the processing for the rights and freedoms of natural persons. Concretely also, Recital 99 provides that associations and other bodies representing categories of controllers or processors should consult with relevant stakeholders, including data subjects where feasible. In Recital 77, it is made clear that codes of conduct are one of the tools that could be used by controllers and processors in order to demonstrate that they do implement appropriate measures and comply with the regulation. Recital 168 also clarifies that implementing acts could target codes of conduct. Article 24(3) sets that adherence to approved codes of conduct or approved certification mechanism may be used as an element to demonstrate compliance with the obligations of the controller. And Article 35(8) on DPIA's Data Protection Impact Assessment stresses that compliance with approved codes of conduct by relevant controllers or processors shall be taken into due account in assessing the impact of the processing operations performed by controllers and processors, in particular for the purposes of data protection impact assessment. Other provisions in the GDPR enhance the fact that supervisory authorities shall encourage the drawing up of codes of conduct and provide opinions and approve such codes. It will be the case also regarding the board. The European Data Protection Board will have, on its own initiative or at the request of the Commission, the obligation to encourage the drawing up of such codes and issue opinions regarding the codes that target different markets in EU. Article 83(2) also leads that when deciding whether to impose an administrative fine and deciding on its amount, due regard shall be given to the adherence to approved codes of conduct. In Article 27 of Directive 95/46, different provisions already laid down what is set in the GDPR. Member States and the Commission having to encourage the drawing up of codes of conduct, taking account of specific sectors, Member States to make provision for trade associations and other bodies representing other categories of controllers in order for them to be able to submit such draft to the opinion of national authorities, and the possibility to submit such codes or amendments or extensions to the working party. A key difference to notice is the fact that seeking the views of data subjects or their representatives was asked either to the supervisory authority nationally or to the working party, and not directly to the controllers or their representatives. What should accountable data controllers and processors get prepared for? They will have to use associations and other bodies representing them in order to have codes of conduct prepared. They will have to bear in mind that EU Commission, the European Data Protection Board, Member States and supervisory authorities nationally will particularly check specific needs of micro, small and medium-sized enterprises. Those codes will address different topics such as fair and transparent processing, legitimate interest pursued by the controller, collection of data, pseudonymization, information of data subjects, rights of data subjects, specific rights of children and collection of their consent, responsibility of the controller, privacy by default and by design, and security, data breaches, transfers, or out-of-court proceedings. Those codes may be adhered to by controllers or processors that are not subject to the GDPR, territorially or materially. Those codes will have to contain mechanisms enabling a body to carry out the mandatory monitoring of compliance with the code. Submission of the code could be done towards a supervisory authority or the European Data Protection Board for activities that would be cross-countries. Supervisory authorities and the EDPB will update a register regarding the codes of conduct. and EU Commission will be in a position to adopt implementing acts and appropriate publicity. So the key question triggered now regards the approval of codes of conduct by national supervisory authorities or by the EDPB.